I too am very grateful to each of the sponsoring organizations that has brought the dialogues together on each of the 10 years, and particularly this year in this very special place. And so on top of that list of thank yous, I want to say in a very general but heartfelt sense, thank you to Nuremberg and to Germany. We are 70 years out from a trial process filled with participants who could not have imagined the Germany and the Nuremberg and the City of Human Rights and the sponsorship and teaching that we're all beneficiaries of today. My topic, the Legacy of Nuremberg, is not a Jackson topic, although what I will end up on is a number of points that I think are Jacksonian. So to a small and, I assure you, modest way, I will try to channel some of how I think he, 70 years back, but looking 70 years and longer forward, would think about the potential legacy of Nuremberg. I want to begin by stepping back from the expertise that you all have to a more general question of what Nuremberg is out there, how to locate it, how to define it, how the word is in play these days. And so I want to name a number of contexts and candidates for thinking about the word and frankly how it gets tossed around. And there are three that I will point to. I did a sort of vacuum cleaner review of popular press in the last few months to try and find the word and see where Nuremberg is being used and how it's being claimed. And first, no surprise, it's used a lot to refer to something about Nazis. Nazis and their crimes. And that really seems to break into two categories. First, there are the real World War II Nazis. For example, outrage in press in the UK about 20 former members of the Waffen-SS who are now elderly gentlemen and retired and receiving pensions in the UK. The Waffen-SS, of course, was convicted here in Nuremberg in 1946 as a criminal organization. So those are some aged but real, senior, and somehow getting away with something Nazis. And in that context, what about Nuremberg is a part of the dialogue. A second, sort of real Nazis, aged Nazis context in which the Nuremberg word and phrase and memory is very much in play is the late German trials of perpetrators. Spät, aber nicht zu spät. Late, but not too late. This is, of course, the Demjanjuk trial in 2011 and the broadened theory of accessory liability, so that he, eventually accurately identified as a guard at Sobibor, was convicted as an accessory to the murders in that camp. The 2015 conviction of Oscar Grüning, who was the so-called Auschwitz bookkeeper. The conviction this spring, 2016, of Reinhold Hanning, who was an Auschwitz guard. And underway this month, although very fitfully, in New Brandenburg, the trial of Auschwitz guard Hubert Zafke, who is being charged with guard work during, coincidentally, the month in which Anne Frank was delivered by train and became briefly an Auschwitz prisoner before she was then shipped on to Bergen-Belsen, where she perished from typhus. So those are, sort of real, if old, and now increasingly scarce Nazis in a context in which Nuremberg is being remembered and is being argued and is being held up as a challenge. The other category of Nazis, if you will, are today's Nazis. And I use this carefully, but I want to talk about how people are pointing the finger and accusing various people of being Nazis. One, this is almost a little amusing, but also deeply appalling, is an aged grandmother, age 87, Ursula Haverbeck. She's a friend of Himmler's daughter. She's the so-called Nazi granny of Germany. And she was convicted this year in Hamburg and sentenced to 8 months in prison for incitement and Holocaust denial. It's just her hobby. And that's against German national law. And she is sort of picking up the Nazi culpability as a speaker and being criminally accountable. Other examples come from odd places. And gingerly I want to point to our friends and colleagues in the Russian Federation. Just last week, at the Commonwealth of Independent States Summit in Kyrgyzstan, the leaders of those former Soviet republics adopted many statements. One noted this 70th anniversary of the International Nuremberg trial and its verdicts and its principles. And at the UN General Assembly last week, the representative of the Russian Federation, among many public statements, spoke emphatically about the need to permit no revision of the history of World War II, no glorification of Nazism. And then, for some reason, the next paragraph was about Ukraine. Russian Federation memory and celebration and rhetoric about Nuremberg and application to contemporary political contexts. The Russian Supreme Court recently affirmed the criminal conviction of a blogger who had reposted an article stating, this should not shock you, that Nazi Germany and the USSR were allies in 1938, 39, 40, and into the middle of 1941, and together invaded Poland in September of 1939. I believe that is not a newsflash. But that is off message and is a basis for criminal conviction in the Russian Federation. Those uses of Nuremberg bridge into a second category that I discovered. And that's the invocation and use of Nuremberg as a high legal standard. It's invoked as a great rule of law achievement, a word that stands for the gold medal, the world championship in some respect. You see this in popular culture. The film Bridge of Spies last year, which portrayed an American-Soviet prisoner swap in Berlin in the 1960s. Tom Hanks portrayed James Donovan. James Donovan had been on Robert Jackson's staff here as an outgrowth of the OSS staff on which he served during World War II. And early in the movie, Tom Hanks / Jim Donovan, who by then was just an insurance lawyer in Brooklyn, but getting drafted into this Cold War intrigue, says, "Of course I was a lawyer at Nuremberg." And it's as if no further resume credential is required. And probably in Jim Donovan's case, that was exactly right. It's more recently captured by Oliver Stone in the current film about Edward Snowden, which says many things, but includes a passing lecture about the Nuremberg principles that the Snowden character, as portrayed by Stone, is acting upon. It is regularly present in dialogue and discussion, professional and popular press, regarding the U.S. military commission process in Guantanamo, which aspired to become regarded in its time, our time, and in history as a Nuremberg of our generation. And the conveners, founders, early, and some wonderfully principled people who had those responsibilities held that up publicly as their standard. And they wanted their work to be regarded as we today regard Nuremberg. And of course that military commission process, now 10 years on since its creation and 15 years on since 9/11 and the war in Afghanistan, is mired in enormous and probably fatal legal and logistical and governmental misconduct issues. So we want to be Nuremberg, and many people using that framework to now say it's not happening. A third context is Nuremberg as just a trope, just outside of legal and operational endeavors, a word of greatness, of significance, of brand value. And you see this, Nexus searches will give you this, in many obituaries and death notices of elderly men who have recently passed on, who once were World War II soldiers. And regularly, it's noted that they attended the Nuremberg trial. For those of you who know Courtroom 600, apparently it had an additional 50,000 seats. If you sort of total up all the people who attended the Nuremberg trial. A favorite and a nod for modesty to one of these gentlemen, and they're all heroes, the greatest generation, another trope is really one that they deserve. But a kudo to this gentleman. His obituary noted wife, children, family, career, hard work, community, and that he was stationed in Europe during the Nuremberg trials. On the other hand, and I hope you catch this as a note of true absurdity. It took my eyes a couple of blinks to kind of notice this one. I spotted a recent letter to the editor where the writer, a fervent member of his community, was making a collateral point and invoked the idea of you shouldn't just sort of say it's your job or you're just following orders. After all, that's what Adolf Eichmann testified when he took the stand to explain how he did the Holocaust as a witness at the Nuremberg trial. Now you think someone would have noticed, right, and perhaps arrested him had Eichmann dropped by to testify at the Nuremberg trial. And sometimes people just get confused about the details. It probably means Rudolf First. So Nuremberg is a word, a big word, a law word, an endeavor word, a history word, a civilian word, a trope that swirls around us and really all around the world. At this 70-year moment, I think we need to step back and to locate what Nuremberg really was. That's a historical project that we all engage in. And then to think carefully about what it means, some of its legacies for us and for the future. Now, I will not presume to teach Nuremberg to this crowd. We are the Nuremberg Academy, in some way, literally and very much professionally and informally, and the historical work is part of the deep background that each of you has. But I will note that today is the first of the Judgment's days. And that's a little bit of a sticky phrase that I use deliberately, because on September 30th and October 1, 1946, the International Military Tribunal, for 2 extensive days, rendered a series, plural, of judgments. September 30th was entirely the day of factual and legal findings. So 70 years ago, seated in the room, listening to the reading, listening to simultaneous interpretation, no one heard anything yet about an individual defendant. That'll come the next day. That was October 1st, which was the convictions and the acquittals, and then in the afternoon the sentences and the end of the International Military Tribunal's work. The first judgments were about what the evidence had shown beyond a reasonable doubt the Third Reich had done as a consolidating totalitarian power here in Germany, and then as a military aggressor, and then as an occupying power and a perpetrator of atrocities across the years of 1933 to 1945. The story of this documentation center. And what the tribunal found, and what the tribunal wrote, in really a substantial book that is underread, the Nuremberg Judgment, is a rich historical record. Of course, it's based on the documentary record that the prosecutors presented, plus the witness testimony. And then, on that factual base, the judgments turn to the validity of the legal theories that the London Agreement, in constituting the IMT, and the Nuremberg indictment, in bringing individuals and organizations to the dock, had presented to that independent tribunal for adjudication. And those judgments found that indeed, the waging of aggressive war, breach of the peace, was by 1946 a crime against the international order. Of course, never previously prosecuted. Of course, never previously the responsibility of an investigative or prosecutorial institution. Of course, for all of those reasons, the subject of much discussion and criticism and some sniping for ex post facto impropriety, etc. The tribunal answered that in one of its judgments 70 years ago, and then followed with similar legal validations of the other theories of the charges, the crimes of war crimes, the Hague and other convention violations, and the crimes against humanity. Yes, in that judgment wrapped within the chronological constraints of wartime, so not pre-1939, but within the 39 to 45 period, those also crimes against the international order. And of course, those are the grounds on which each of you has grown and built the tribunal processes, the international agreements, the case and investigation endeavors that you are connected to. So I want to turn to Nuremberg as it really was recognizing that there are many judgments that are our starting points, that the law and the history is really part of it. But here's the first one that I think is too easy to forget. Nuremberg was about winning a world war. It was a war-won endeavor. Robert Jackson used the phrase that Nuremberg was a emphasis by me on that first word, post-mortem of the Third Reich. In other words, the Nazis had been killed as in militarily defeated as a predicate to what Nuremberg was able to do. And indeed, as you see in the maps, including here in the Documentation Center, Nazi Germany no longer existed. May 8, 1945 was an unconditional surrender, which meant an entire relinquishment of sovereignty, which meant an entire military occupation and a division into sectors of military control and total power. And frankly, without that base, without that victory won, Nuremberg doesn't happen as it did. A second thing connected to that Nuremberg was and is as a legacy, is a moment, a shining, brief, perhaps moment, of political power and political will. Succeeding war, succeeding Nazi Germany, in the occupation, and in broadly the world's 1945 moment, there was a consensus, a broad, deep consensus. It's easy to see in a binary process, a world war pitting evil against good, in which good prevails, leaves the consensus of the good team, which is the United Nations, small u, small n, who then embark on the United Nations, capital U, capital N, and the International Military Tribunal created by the London Agreement, and the Universal Declaration of Human Rights, and the Genocide Convention and the Geneva Conventions, and the things that were possible during that short interval of time from 1945 until, let's say, the spring of 1949, when Telford Taylor and his colleagues concluded the last of the subsequent proceedings, the Ministry's case. And it was only that power and will and consensus that made Nuremberg happen as it did. A third point in thinking about finding Nuremberg and focusing on what its core legacies are is to take very seriously their war focus. They used their victory and they used their power and consensus to look back on what had happened and at the core of it identify the war waging as the evil. The supreme international crime, in Robert Jackson's words. A crime against the international order in the judgment of the Military Tribunal. The chronological bracket in which everything else that Nuremberg is about found to be the basis of criminal liability. Now, broader and more modern and important thinking ranges beyond that, but I think there is an important argument to be made, and here I am just surfing on the words in Life and Legacy of, among others, Ben Ferencz, that at the heart of concentric circles of evil, the center evil is war. That was Robert Jackson's view. That was the Nuremberg view. That was one of those judgments of 70 years ago. A fourth thing that Nuremberg was, and that its legacy is for things that seek to be most like Nuremberg, is in situ. Nuremberg was about Nazi Germany, and it happened here in what had been Nazi Germany. And when I say in situ, I mean not just geographic landmass, I mean crime scene. I mean physical devastation. The old city we built beautifully behind me was, of course, stacks and stacks of rubble, and the stench of decaying bodies, and desperate, starving people. But the crime scene wasn't just those things that are easily captured in the photographs. The crime scene in the experience was the displaced persons camps that surrounded Nuremberg, including very close to the Palace of Justice. It included the remnants of survivors who weren't in those formal facilities, but for example, were living under plywood sheeting across tombstones in the desecrated Jewish cemetery that's within 2 blocks of the Palace of Justice. It includes the remnant survivors of the Jewish communities of both Nuremberg and Fürth. Some who stayed and hid and were maintained, and some who fled, and some who were imprisoned and trickled back, and they were only remnants. But they were tangible, physical remnants of the human depredation And they were very much in the sight lines of everyone who was a lawyer and an investigator and an interrogator and a jurist at Nuremberg. Indeed, I have to disclose one of my favorite Nuremberg crimes. Robert Jackson's staff, which of course grew to be a very large one, included some very wonderful lawyers who did very good work and killed themselves by day being lawyers. But by night, they were human beings, and they did some R&R and spent some time in the Grand Hotel and danced in the Marble Room and fraternized and etc. But not all of them. A couple of particular straight arrows, and they happen to be Jewish lawyers on Jackson's quite heavily Jewish staff on the front half of the trial particularly, were very aware of the refugees. And what they did, I'm sad to report, except for their being deceased and the statute of limitations protecting them, is they stole a lot of ice cream. And they took that ice cream from the military PX, where it was soldier ice cream, if you will, and delivered it to these synagogue remnants and these displaced persons camps and these little children who were 7, 8, 9 years old. And through parties, a Rosh Hashanah party, we're about to hit that holiday, a Christmas party in December, etc. So, a good use of Allied largesse. Nuremberg in situ, in other words, means the whole package and the prosecution investigation endeavor being in the theater, in the nation, on the landmass connected to the people. Now that's very hard to do as a general matter, and many of you have and do deal with situations where that is impossible. It is the total victory and the total military occupation that made it possible, but that is my point. At the heart of the Nuremberg legacy, that's an important thing to understand about what was possible. A fifth dimension and a fifth legacy that I want to point to is the necessity of Nuremberg, that this, in their view, had to be done. It was a response to self-evident horrors that the Allied nations had confronted, first as adversaries and as military forces, and then at the governmental and diplomatic and policy and occupation levels as the successors to deal with this. Walking away, calling it a day, concluding the war by being fatigued and not doing anything more was an implausible alternative, never really considered. And of course, at the other extreme, brutal, large-scale executive actions, firing squads and so forth, were another alternative, not really considered. In Jackson's phrase, that one, although in the moment connecting with plenty of righteous vengeance, would have been a path that neither we, Jackson speaking, nor our grandchildren, us, would look back on with pride. So in between doing nothing and doing too much in brutal response, the need was to do this trial process. And I think it's captured in the last paragraph of Robert Jackson's closing statement to the IMT, July 26, 1946. This is much quoted, but I think not much unpacked. Robert Jackson, a man of words, a man of a beautiful pen, was a close lifetime student of Shakespeare. He'd been drilled as a boy by an English teacher and read Shakespearean plays at her home into the wee hours in front of the fireplace. And he memorized, because that's what people did with oratory and literature back at the start of the 20th century. And then, decades later, he's here in Nuremberg. He doesn't have the collected works of Shakespeare in his house. But he's got a fair amount of Shakespeare packed in his mind. And thanks to the National Archives, you can see the drafting of his closing argument, and you can see him write out, longhand, a passage from Richard III. It's the scene where Gloucester is confronting the Queen over the body of the murdered king. And he begs her to sort of let it go. Say I slew him not. Robert Jackson quotes that line, and then turns to his application of it in the context of Courtroom 600 in 1946. He said, quoting the Queen, I could say you slew him not, but dead he is. And then Robert Jackson says, it would be as true to say in this context, that there was no war, there are no slain, there is no crime. Say I slew him not, but he's dead. Say we're not guilty, but there was a war. But there are dead. But that is a crime. And that is a conviction of emotional and intellectual necessity that is unable to contemplate an alternative. Yes, you can quibble about the formal propriety of the creation of this institution, the pre-existence of these legal norms and so forth. But at the moral human level, look at this. This is a no-brainer. This is a crime. And that mindset of necessity at the core of evil was Nuremberg and is the best, I think, of modern international humanitarian law. It is where the consensus, without much persuasion and without much complex diplomatic work, can look and say, that's it. That is a crime. Nuremberg also was connected an educational process. It, of course, was a documentary case. Robert Jackson had, maybe for a little bit of ill from the perspective of people who wished not to be bored in Courtroom 600, he had been the head of the Antitrust Division in the U.S. Department of Justice for a year. He knew documents cases. And in one respect, the Third Reich was prosecuted like Alcoa had been prosecuted by the U.S. Department of Justice in the late 1930s for market domination and price fixing. It was all there in their records. And you present the documents and you read it and you teach the story and you obtain the verdict. Now, of course, metal market monopolization is not anywhere near as important as what these records were about. And the educational process was, of course, in the context of carrying a burden of proof and convicting individuals and convincing the tribunal, but it reached the external audience. And that documentary record is, of course, the published record of the Nuremberg trial, which is, of course, the foundation of our historical understanding of the Third Reich, which, of course, is an ongoing repository of depth and complexity that every generation makes new and better use of, and allows us to wrap our minds around the biggest and most incomprehensible of the horrors that were World War II and Nazi power. In that amazing, ambitious, conclusory, determined, necessity educational process, another thing I do want to note about Nuremberg is that it was efficient, it was selective, and it was brief. It happened in what Jackson even bragged at the time was an amazing hurry. To go from nothing, May of 1945, no institution, no evidence, no agreements, no nothing, to the commencement of a trial 5.5 months later, he said was faster than many automobile injury cases get to trial in New York State. And that's still sadly true. Now, it was efficient because the tribunal then ran a tight ship. These judges met and sat for 6 days a week and long days. And they rationed witness allocations to the defendants and then cracked down on extraneous demands. They delivered documents in summary forms and cut down on slow-rolling moves that would prolong that process. Part of it was the political will wasn't perhaps infinite political will, it was also impatience. But part of it was a commendable commitment in focusing at the core to get right to it. My eighth and final dimension of what Nuremberg was, and thus what its core legacy includes, is that it was carefully optimistic. And I do mean both of those words. Yes, its optimism included some very high universal ideals. The poison chalice line, which Jackson, by the way, of course, did not ever speak, but he wrote and then published. I think he didn't speak it in the courtroom because, of course, he swiped that from Shakespeare too, and it was a little bit perhaps too obvious or a little bit too blatant. So he had it in his opening statement and then put a line through it and didn't say it when he delivered the opening statement. But the idea of we hold ourselves to these standards too was the high universality of Nuremberg. But it stayed within the Allied consensus. And frankly, the Allied consensus was that perilous alliance of the USSR and the US and the UK particularly, that Soviet show trial instinct against the American-British due process instinct, that had been just barely worked out and bridged over at London and got here to trial. And they didn't push it too far. They didn't, of course, put themselves in the dock too, and that's a fair criticism. But the people they put in the dock were the ones they focused on for the core evils they had perpetrated. And they were careful and very skeptical in the aftermath of Nuremberg in embarking on projects to try to codify this too much, too broadly, too permanently, to put words on paper that the world would never live up to. Yes, the UN General Assembly in December of 1946 adopted the London Agreement and the Nuremberg Judgment. And it's sort of that brief and conclusory as a label matter. And yes, in that same December of 1946, the Genocide Convention proposal, Lemkin's great project, is also sent forward by the General Assembly. But the idea of a code of crimes, the idea of a charter for a permanent international criminal court, was something that, of course, not only the Soviets were quite cautious about in 1946, but the Americans and the British, and particularly Robert Jackson, Charles Fay, his counterpart, who was a Berlin legal advisor and then became the State Department legal advisor, etc. And why? Not because they were soft on their universality and the high ideals, but because they were practical about making progress. And having gotten Nuremberg done and held that consensus together to get that done in the heart of those concentric circles, they realized it would be a backsliding and a perilous step to sort of jump out to the periphery and try and be too utopian. On the other hand, in the aftermath of Nuremberg, each of them was more than willing and happy to do his part and go as far as the United Nations could. Not farther, but all the way that far. And thus, politics and negotiation and discussion and fitful endeavors, which is how we get from October to December of 1946, were very much things that they were willing to do too. And that is a kind of push and pull, hydraulic process, utopian idealism, visionary leadership, and pragmatic political pullback skill that they toggled very well as a Nuremberg generation. And I think most of you in your daily work have that more or less as your job description. Where does all of that leave us? That Nuremberg was, in its location and in its legacies, war-winning, power and political will, a focus on aggressive war, a located proceeding in situ, a necessary endeavor, an efficient endeavor, and a carefully optimistic educational endeavor. Where does that all leave us? Well, it leaves the world, and those of us who are in the heart of the expertise as teachers and leaders using this word, with the brand, with that model, and with that broad responsibility. We each try in our ways to teach it, because really to get it requires the careful study of it, not merely the light invocation of it. That means reading it. That means debating it. That means critiquing it. That means recognizing that it's a very fallible human endeavor, not a case for anybody's sainthood. When we do all of that, and I think the International Humanitarian Law Dialogs are one of the proudest parts of the tradition of doing that, we and our successors are better positioned incrementally to live up to it and to build upon it and to take Nuremberg to numbers that are much bigger than 70. I close with a little Robert Jackson phrase that I probably quote too much, but it's short. It's a little antique phrase. A man in 1892 would trot out, born in 1892, would trot out a phrase like this. He said, "The meaning of Nuremberg will become clear in the century run." The century run. He was age 53 and 54 a very young man, I now think, at Nuremberg. And he was dead at age 62. And we are 70 years down from 1946. And we've got 30 more to go before we touch the century run. And so I'm grateful to be involved in sharing that project and continuing to do that work with each of you. Thank you very much.